Rules of Court, Rule 58, Preliminary Injunction, Section 1, Preliminary Injunction Defined, and Classes. A preliminary injunction is an order granted at any stage of an action or proceeding prior to the judgment or final order, requiring a party or a court, agency, or a person to refrain from a particular act or acts. It may also require the performance of a particular act or acts, in which case it shall be known as a preliminary mandatory injunction. Section 2. Who may grant preliminary injunction? A preliminary injunction may be granted by the court where the action or proceeding is pending. If the action or proceeding is pending in the Court of Appeals or in the Supreme Court, it may be issued by the said court or any member thereof. Section 3. Grounds for issuance of preliminary injunction. A preliminary injunction may be granted when it is established A. That the applicant is entitled to the relief demanded and the whole or part of such relief consists in restraining the commission on continuance of the act or acts complained of, or in requiring the performance of an act or acts either by a limited or perpetually. B. That the commission, continuance or non-performance of the act or acts complained of during the litigation would probably work injustice to the applicant. C. That a party, court, agency, or person is doing, threatening, or is attempting to do, or is procuring or suffering to be done, some act or acts probably in violation of the rights of the applicant respecting the subject of the action or proceedings, and tending to render the judgment ineffectual. Section 4. Verified application and bond for preliminary injunction or temporary restraining order. A preliminary injunction or temporary restraining order may be granted only when A. The application in the action or proceeding is verified and shows facts entitling the applicant to the relief demanded, and B. Unless exempted by the court, the applicant files with the court where the action or proceeding is pending a bond executed to the party or person enjoined in an amount to be fixed by the court, to the effect that the applicant will pay to such party or persons all damages which he may sustain by reason of the injunction or temporary restraining order if the court should finally decide that the applicant was not entitled thereto. Upon approval of the requisite bond, a writ of preliminary injunction shall be issued. C. When an application of writ of preliminary injunction or temporary restraining order is included in a complaint or any initiatory pleading, the case, if filed in a multiple sala court, shall be raffled only after notice to and in the presence of the adverse party or the person to be enjoined. In any event, such notice shall be preceded and contemporaneously accompanied by service of summons, together with a copy of the complaint or initiatory pleading and the applicant's affidavit and bond upon the adverse party in the Philippines. However, where the summons could not be served personally or by substituted service despite diligent efforts, or the adverse party is a resident of the Philippines temporarily absent therefrom, or is a non-resident thereof, the requirement of prior or contemporaneous service of summons shall not apply. D. The application for a temporary restraining order shall thereafter be enacted upon only after all parties are heard in a summary hearing which shall be conducted within 24 hours after the sheriff return of service and or the records are received by the branch selected by raffle, or to which the records shall be transmitted immediately. Section 5. Preliminary injunction not granted without notice. Exemption. No preliminary injunction shall be granted without hearing and prior notice to the party or person sought to be enjoined. If it shall appear from facts shown by affidavits or by the verified application that great or irreparable injury would result to the applicant before the matter can be heard on notice, the court to which the application for preliminary injunction was made may issue ex parte a temporary restraining order to be effective only for a period of 20 days from service on the party or person sought to be enjoined, except as herein provided. Within the 20-day period, the court must order said party or person to show cause at a specified time and place why the injunction should not be granted. The court shall also determine within the same period whether or not the preliminary injunction shall be granted, and accordingly issue the corresponding order. However, subject to the provisions of the preceding section, if the matter is of extreme urgency and the applicant will suffer grave injustice and irreparable injury, the executive judge of a multiple sala court or the presiding judge of a single sala court may issue ex parte a temporary restraining order effective for only 72 hours from issuance, but shall immediately comply with the provisions of the next preceding section as to service of summons and the documents to be served therewith. Thereafter, within the aforesaid 72 hours, the judge before whom the case is pending shall conduct a summary hearing to determine whether the temporary restraining order shall be extended until the application for preliminary injunction can be heard. In no case shall the total period of effectivity of the temporary restraining order exceed 20 days, including the original 72 hours provided herein. In the event that the application for preliminary injunction is denied or not resolved within the said period, the temporary restraining order is deemed automatically vacated. The effectivity of a temporary restraining order is not extendable without need of any judicial declaration to that effect, and no court shall have authority to extend or renew the same on the same ground for which it was issued. However, if issued by the Court of Appeals or the member thereof, the temporary restraining order shall be effective for 60 days from service on the party or person sought to be enjoined. A restraining order issued by the Supreme Court or a member thereof shall be effective until further orders. The trial court, the Court of Appeals, the Sandigang Bayan or the Court of Tax Appeals that issued a preliminary injunction against a lower court, board, officer, or quasi-judicial agency shall decide the main case or petition within 6 months from the issuance of writ. Section 6. Grounds for objection to or for motion of dissolution of injunction or restraining order. The application for injunction or restraining order may be denied upon a showing of its insufficiency. The injunction or restraining order may also be denied or, if granted, may be dissolved on other grounds upon affidavits of the party or person enjoined, which may be opposed by the applicant also by affidavits. It may further be denied or, if granted, may be dissolved if it appears after hearing that although the applicant is entitled to the injunction or restraining order, Again, Section 6, grounds for objection to or promotion of dissolution of injunction or restraining order. The application for injunction or restraining order may be denied upon a showing of its insufficiency. The injunction or restraining order may also be denied, or if granted, may be dissolved on other grounds upon affidavits of the party or person enjoined, which may be opposed by the applicant also by affidavits. It may further be denied, or if granted, may be dissolved. If it appears after hearing that although the applicant is entitled to the injunction or restraining order, the issuance or continuance thereof, as the case may be, would cause irreparable damage to the party or person enjoined, while the applicant can be fully compensated for such damages as he may suffer, and the former files a bond in an amount fixed by the court, condition that he will pay all damages which the applicant may suffer by the denial or the dissolution of the injunction or restraining order. If it appears that the extent of the preliminary injunction or restraining order granted is too great, it may be modified. Section 7. Service of copies of bonds. Effect of disapproval of same. The party filing a bond in accordance with the provisions of this rule shall forthwith serve a copy of such bond on the other party, who may accept to the sufficiency of the bond, or of the surety or sureties thereon. If the applicant's bond is found to be insufficient in amount, or if the surety or sureties thereon fail to justify, and a bond sufficient in amount with sufficient sureties approved, after justification is not filed forthwith, the injunction shall be dissolved. If the bond of the adverse party is found to be insufficient in amount, or the surety or sureties thereon fail to justify a bond sufficient in amount with sufficient sureties approved after justification is not filed forthwith, the injunction shall be granted or restored, as the case may be. Section 8. Judgment to include damages against party and sureties. At the trial, the amount of damages to be awarded to either party upon the bond of the adverse party shall be claimed, ascertained, and awarded under the same procedure prescribed in Section 20 of Rule 57. Section 9. When final injunction granted. If after the trial of the action it appears that the applicant is entitled to have the act or acts complained of permanently enjoined, the court shall grant a final injunction perpetually restraining the party or persons enjoined from the commission or continuance of the act or acts, or confirming the preliminary mandatory injunction.